to take our unique story into the future. This is your lifetime opportunity to name a rhino, and with it, find the conservation efforts that keep our story alive. For more information, visit our website www.ugandawildlifeauthority.org.
Hello, Kampala, Uganda. In response to the national call of strengthening the traffic security, Good Products Group HGO brand has officially launched the Rider Selection Campaign. Registration is now open. Visit www.riders.hgo.com. Complete your registration now for a chance to win exciting prizes including motorcycles, exclusive HGO gift boxes, and official rider vests, all while promoting safe riding awareness. This is how to participate. Pay the registration fee, invite 3 friends to form a team of 4, and your registration fee will instantly be refunded. Begin your journey of honor today. Don't miss this opportunity. Join the challenge, promote road safety, and become a pioneer rider. For details, visit the official Good Products website at www.hgo.com or call toll free 0800-335-555 or visit our offices at Kingdom Kampala 3rd floor to register now and win prizes worth millions.
Taxation is a bit complicated, and the only way to demystify it and make it as easy to understand and to comply with is through engagement. Is there a limit to the number of cars a returning citizen is bringing into Uganda? Who has paid the excise duty on this water is not the supermarket which has sold you this bottle at 1,000. It's not the business. It is the man who is going to drink this water. We strongly believe that it will only be through such constructive engagement that we'll be able to broaden our tax base and build our country together.
Buza Commissioner. Now you can get direct answers. Send your tax-related questions via WhatsApp or SMS to 0790-141-887, and the Commissioner General of URA, John Musinguzi, will personally address them. Tune in to UBC News Tonight every Monday and Wednesday for expert insights and clear explanations. Buza Commissioner.
In a nation hungry for truth, a world where every story matters, there exists a beacon of trust and reliability. For decades, they've been our voice and our window to the world, holding the mirror of our history. With 4 TV stations and 11 radio channels spanning 27 languages, they stand as guardians of information, defenders of truth. With Mascari Heritage Advantage, they uphold every citizen's right to reliable and free information. Their archived stories shaped our past and illuminate our present. Yet now, as new challenges arise and the world evolves, their mission faces its greatest test yet. Be part of our journey and let's navigate the unknown, uncover the untold, and safeguard our future together. Tune into your public broadcaster, for it is the intersection of trust and truth. Because to UBC, your story, and every voice matters. UBC, inspiring Uganda.
Junko.
Yo.
Wachikuwa. Check the shopping, man. What's your secret?
Uganda, haven't you heard of the parish development model PDM?
Yes, I did, but I thought it was just a talk.
No, Sebatia. It is real. I and a few friends together formed a circle, accessed money from the PDM, invested in a poultry project, and now things are moving.
Junko. I thought I was one of your friends.
You are.
But you left me behind.
I didn't leave you in poverty. What you do, just visit your LC2 chairperson and your parish chief and start the process of economic transformation. Just like that. The parish development model is an initiative from the government of Uganda through the Ministry of Local Government designed to transform all lives of Ugandans for the better. PDM, my parish, my development, my life.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
Good morning and thank you so much for being with us on UBC TV. Welcome to this special edition of Friday where I am going to be discussing something very important, and I know some time back it's been making headlines, and that is recusal, law and practices in court. Recusal, law and practices in court, or practice in court. Do you know what this is? Well, these are terms used by the land fellows. And on set, I'm honored, I'm humbled and privileged to be having the spokesperson of the judiciary. That is His Worship Elemie James Mawanda. He's with me in studios. Your Worship, you're most welcome.
Yeah, thank you very much. I want to thank you for hosting me this morning to discuss a very touchy issue which is making rounds. And as a judiciary, it's our responsibility to set the record straight.
And I'm happy
yes,
that you accepted our invitation to respond to these issues.
Also glad.
Because most of what happens in the judiciary, we do not understand. And also have that fear of the judiciary. I want to tell you, Your Worship, if you told someone that you're going to meet a judge, an ordinary Ugandan, you would see how they would tremble. Now, the fact that courts are also something, a temple of justice. Even we fear court. One time I escorted someone at High Court, but he was as if he's in the presence of God. I could see this person entering there, that fear now. Some of these things that happen for us, the layman out there, when they hear, you know, these things are, so I'm happy that you're here to explain this.
Thank you.
And now, to begin with, let's first understand recusal. What is this term? What does recusal mean in law, but simplify it to the ordinary Ugandan?
Thank you very much. Our dear viewers, good morning. And I bring you greetings from the judiciary, right from the Honorable the Chief Justice, the Deputy Chief Justice, and the top management. First of all, I want to inform you that as a judiciary, we are excited. We have a new principal judge appointed, and we want to welcome our lordship back home. You know, she was our person, so when she comes back, after having gone a little on an assignment, and she did well, and now she's back. For us, we're excited. We are going to build on that experience she has had from the outside, and we see that as a judiciary, we continue moving forward. And to greater heights, because our vision is justice for all. To answer the question on recusal, specifically, allow me firstly the background, because a person listening in and viewing may want to understand how does this thing called recusal come about. In the first place, the judiciary is a creature of the Constitution, and we are servants of the people. If you are a servant of the people, it means you render a service, and this service is premised on frameworks that ensure justice for all. And in so doing, our mission is to ensure that we do it efficiently and effectively. Now, Article 28 of the Constitution brings in fair trial. That anyone who goes before a court must be handled in a fair manner, and due process must be observed. Now, when it comes to Article 126, we look at the tenets that a judicial officer must follow when he's handling work.
Yes.
One of them is the question of impartiality. You know, impartiality, even in our judicial code of conduct, is a core value, that you must be impartial, and you must therefore not be a judge in your own cause. What does that mean? That
in a layman's language, you would say you must be neutral.
Neutral.
Neutral, yes.
Neutral. You are
take
an
no
arbiter.
side.
You are a referee. Although I have seen recent football where referees were being accused of some biases. But the question here is impartiality. And if you are impartial, all issues of bias, okay, against a party, all issues of conflict of interest in the case that you are handling or sitting in, all manner of prejudices that come by for reasons of perhaps knowledge of parties before you, or influence peddling that might arise in the course of the handling of the matter, etc. Now, over time, we have had many of these cries. Ugandans crying this, crying that, crying this. Much of it sometimes is a misunderstanding of the processes and the law.
Yes.
But by and large, our operating slogan is justice must be seen to be done, must be seen to be done, and also you know that
felt,
you see, must not only be. See, we speak about justice and people hear us speak about justice, but other than speaking about it, it must also be seen that we are doing it.
Yes.
You understand that? Therefore, because of the many situations where people come in and then they are uncomfortable with our judges, our judicial officers, the magistrates, the judiciary came up with a framework, a legal notice, which is the Constitution Recusal of Judicial Officers Practice Direction 2019. And it was brought to cure certain mischiefs. One of them was, if a judicial officer is conflicted, he should recuse himself from the matter, because he definitely cannot render justice in
so
the matter.
recusal simply means excuse yourself.
Excuse yourself from sitting in the matter because you are conflicted.
You have pain already. Now how can you adjudicate over?
You are interested. I will use the most obvious example. Robert, you are my friend, isn't it? We are here, we sit in this discussion. Of course, we have developed a kind of personal relationship. You are in the media house, you're on UBC. I sit in High Court or whatever I do. And then you have a case remotely. May not be you directly, but it could be a case of your relative. And you knowing me, say, oh no, I know PRO, judiciary, this is my friend.
It's my friend.
They even tell you when you go home. They say, hey, this man you normally sit with on UBC, this one who talks for the judiciary, you know, they use those words. He's the one sitting in my case. So they say, okay, and they will demand that you talk to me. Otherwise, they will throw you out of the clan. In fact, the whole family, they will throw you out. So you get, obligated. So you give me a call. And once you give me a call, you are telling me, this is my auntie, she told me or whatever, the case is before you, please, can you help? Now, that alone conflicts me. Because how best then am I going to be just to the other party when I already am? So
how will Robert see it that I sentence?
It
is within my power.
Yes,
and I'm a friend.
And that's the irony. That I know the law, the facts are going to be brought before me, but now what will my friend Robert say? So the best way to do it under the law is you recuse yourself. You recuse yourself such that the matter is put to another judge or another judicial officer to handle it. Now, the practice direction I mentioned allows judicial officers by themselves. Because you see, you look at parties and you look at the matter, and you are able to determine by yourself whether there is a conflict of interest that will affect your impartiality. So that at the end of the day, you have no bias at all. So you do it yourself. You inform the parties, I'm conflicted by A, B, C, D, this reason and the other, and therefore I am recusing myself. Because they need to understand, why are you getting out of their case?
You're supposed also to give the reasons.
You see, the judiciary runs on principles of transparency.
Okay.
And we have told you, this year's our theme has always been transparency, you know, in the effective administration of justice. So we, as a judicial officer, it starts with you. The practice direction requires the judicial officer himself to first examine himself in relation to the case and the parties before him. And thereafter, inform. He moves himself, by the way, the moment he realizes that it is. If there is no element of a conflict of interest, he's good to go and proceed with the matter.
So it's first person examination.
Person examination. Because why? We were having so many of those complaints coming in. This judge is biased, this judge is biased, this judge is biased. Until we said no. Judges, judicial officers, magistrates, first examine yourself so that we remove that apparent bias which people keep on speaking about.
And which is the obvious? Someone is losing a case.
I'm telling you.
It is very easy for them to say, no, this judge is biased.
60% of complaints are bias related against judicial officers. Bias. Because people perceive how we conduct ourselves in court in different ways. Even when, now for me, I have a problem, I naturally smile. Now somebody will say something and I will smile, you know. And sometimes I say, you see, he knows this one.
I saw that judge.
Did you see?
He was really smiling.
He was smiling. So it's natural to some of us. But that has nothing to do with how I'm going to decide the case. It could be how I'm appreciating the point that I will definitely capture in my decision. And I'm saying, okay, that's very good, all right. Now I'm picking. I even encourage you to get the best out of a party, because it's my duty. I must understand the party's issues properly. So gestures, motions, how you do, etc., the non-verbal communications, even the verbal ones, have a lot to do with how people perceive our sitting in judgment. Therefore, you examine yourself, and if you have no problem, you are good to go. However, there is recusal at the instance of the parties. This is where a party comes up and says...
So first was the judge examines he or herself and says, no.
No, I will not sit in this because I'm conflicted.
And then he will give the reasons.
He will give, definitely.
Okay, now we go to second.
Then the second one is where a party, for all reasons' sake, will move the court to recuse from the matter. Okay? I want to use the example of Honorable Dr. Kizabesigiano. The lawyers, they did apply to court, asking the judge sitting in the matter to recuse. Now, when such a party, or by his advocate, orally in court, when the matter is on, and or in writing, stating the reasons, that letter will be served today to the court. The registrar will receive it and put it to the attention of the judge. Now the judge will have to listen to that application because it is either in writing or orally. The judge will listen to the reasons that you have given. And the judge will make a finding about those reasons. Remember, you are asking the judge and you are imputing all your grounds on the judge. And so the judge must answer. Yes, the judge answers because you have put it in. You are telling him, my lord, you are biased in this matter and these are my grounds.
Yes.
In this particular instance, the particular case I'm talking about, I have, because it's already, we are talking about the recusal, which was already decided. We are not talking about the merits of the matter before a court, but just the solution for purposes of this discussion.
Yes.
The judge in the application was being asked to recuse simply because, in their view, they thought that he had delayed to fix their application for bail. And in so doing, for them, they say it was bias.
Why delay?
Why did you delay? Those are the questions they were putting to him, and for the court was asking, the court to ask itself whether delay therefore constituted a bias. And the honorable judge ruled that delaying it to fix a matter, okay, where one, the application was filed on the 22nd of April, 2025. It was allocated to the judge on the 28th of April. But as the filing and allocation was going on, the judge had already matters fixed for those preceding days. And they were having an in-house session. You know, criminal division now handles what we call daily hearing. Unlike then when they used to sit in session programs. Today, the criminal division sits daily to hear matters. If your case is brought today, they will hear it today, tomorrow, the other day. Now, there was already moving matters. And so space within which to fix the case was not available within the shortest time they wanted the matter to be fixed. Remember, we are talking about bail. But the court has already fixed matters that are ongoing. There are even also bail applications among them. So the matter then was fixed for the 15th of August, having disposed of what was already on their table. You understand that? And so when the matter came up, that's when they brought recusal because you delayed. And the judge, listening to them, also made a finding that no, that and any other reasons they raised did not constitute bias to warrant a what? A recusal. Now, I want to tell you this. When we did not have this guidance from the Honorable Chief Justice on recusal to become our law and practice in the courts, we used to have so many cases losing track, losing position, ending up in a backlog because people would come up saying, recuse yourself, you are biased, and you know, it ended up frustrating our judicial officers because they want to do justice, and they believe they are doing justice. However, parties come up with all sorts of reasons to ask for recusal. And most of the time, judges would, judicial officers would find it more comfortable to recuse.
Yes.
Again, let me get out of your case. If you think that I am not going to give you justice in your view, either it's me, I'm going to give you justice. Okay.
So also, I wouldn't take it in good faith if I'm doing all it takes.
Many judicial officers would recuse, and then we have a piling of cases where there is no judicial officer to handle them. And then we are again complaining about case backlog.
Now, let me also, Your Worship, let me get this. Now, if I recuse myself of a case, what is the procedure of someone to take it on another judge?
Of course, when you recuse
because
yourself,
I believe when I'm in a case, I've followed. I've followed this case, I've read the facts to a certain point. I have the history, I want to assume. I'm not a judge, but I want to assume that if a specific magistrate is handling my case, they know the history of the case. So if I reach a certain point, that means then the new judge who is coming on has to study the history of the case, the merits and all that, then be in position to continue with the case.
Exactly. That's it. But I will tell you this, that every legal framework that comes up has a reason, a mischief it is intended to cure. We are fighting case backlog. We are coming up with case management strategies and interventions that will enable Ugandans achieve Article 28 fair trial, Article 26 on expeditious trials, etc., and the absence of technicalities. Rekuzo came in to assist in a situation. Remember, all judicial officers, and this is what my brothers and sisters on the bar are failing to understand. The moment you become a judicial officer, first of all, these judicial officers are not just picked from the streets. They go through a very rigorous vetting system for them to be appointed judicial officers, right from the lowest rank to the highest court. Now, these judges are vetted, they are found worthy, they are very competent, and so they take a judicial oath to administer justice to all manner of people without fear or favor. And our judicial officers, remembering that that was their judicial oath, upholding the Constitution and administering justice without fear of favor, discrimination, or ill will to all manner of people, as God helps us all. It empowered them to properly use the Practice Direction 2019 on Rekuzo absolutely well. It gave them the confidence, if you feel you are not conflicted, like the Honorable Justice Manuel Magoma in this matter felt he had nothing to conflict over this matter. And two, that the grounds were not
This looked at this as technical, you know, how can I say it? There is something that can be technically done. Like once a technical knockout, like the delay, they view it like, well, technically we can drag this. Technically.
I was coming now to that.
Yes. Because I've also understood one thing in court, your worship, that there are some technical things in court that for us, the layman, you need to have extra spectacles to understand them.
No, but first of all, Article 126 down there has guided the courts on how to manage technicalities in the courts.
Okay.
Because substantive justice shall not be defeated because of a reason of what? Matters of technicalities, matters of form, etc. But I want to bring you back to this discussion that the Honorable Judge of the High Court, in sitting in the Criminal Division, they did not find any merit in the grounds that because he delayed to fix a case, that therefore should constitute bias. And he said, no, that doesn't constitute bias in my view. Okay? Probably if there were other reasons. But merely that I delayed, when I even have reasons, I have everyone before the law is equal. But I've told you, we have, the Criminal Division is now running a daily hearing program. Now, so these judges already have matters, okay, but on a daily. And this application was brought at a time when honestly, they already have matters fixed. It doesn't make sense to fix your case and I can't hear it. Doesn't make sense. In case management, you should be able to plan your caseload. You should know when to bring which case, when to do ABCD, ABCD. And our good friends, the public and court users, should understand that. When you go on EKIMIS, you are able to see, you know, these are transparent things. We are now we are in the okay, e-governance. Yes. You are able to see that do I have space in between there so that I can press the court to fix my case. Nonetheless, it was fixed, and then the application for recusal came in, and the judge ruled otherwise. Now, I want to show you where the problem is. One, we have a party who wants an application for bail. Fixed. Because you see, bail is a pretrial remedy, where you see, as your case is going on, you are granted bail to come from home. You leave prison.
And we love saying it is our constitutional right.
Everybody wants to leave prison and answer to their matter while they are away from prison.
Yes.
So that they come from home. That's the essence of bail.
Incarceration is
bail
not
and then the application. So the elements of urgency are true. However, what about the schedules of the court? But number two, we also know that recusal, not, and I'm speaking now generally, away from this particular case,
yes,
was abused by people. And that's why we have case backlog. Because I told you earlier, there was uncoordinated requests and applications and motions for judges and judicial officers to recuse. And then they would want to give the people the justice. So if you believe that that's why you'll get justice, okay. But you are asking me to recuse? The matter is given you to Bob. Bob, they also ask you to recuse. They ask the other one to recuse. At the end of the day...
That is wasting time of the judiciary.
Now, this case starts makes rounds. And at the end of the day, there is nobody willing to. In fact, even a judicial officer, I told you at the beginning, a judicial officer can recuse himself and say, and he, by the way, you don't need... may not even need to give reasons. You say, no.
I remember, I just want to recall that case where at one time it was hard to find a judicial officer sitting in it because everyone would recuse themselves that was being appointed. I know my hard disk will give me that very soon in that case. So, and every judge, like, no. So it delayed for some time just because every magistrate felt that maybe the previous was not appreciated, and therefore they never wanted to come, I think, in that drama of Ajo Mutambo. You know, I love the way Uganda news broadcasters say, Aje Mutambo Mumusango, something like that. Then you're going back to look for another one.
So, here is where the judiciary has taken it on to ensure that we come and educate our public. Now, when a judicial officer, upon the instance of the parties, does not recuse himself, and this is where I want our friends to understand and remember their law. We have been drumming up all advocacy and efforts to ensure that we follow the rule of law. This recusal, constitution, recusal of judicial officers, practice direction is law. And my brothers on the bar, they know it. They know it. It's law. And the practice is available. They know, they have lived it. And we are saying, let us not mislead the public. You know very well that when a judicial officer, upon an application at the instance of the party, to recuse, rules otherwise and does not recuse himself from a matter, you know the law says that the reasons for his refusal to recuse will be recorded and the matter will proceed. Do you know why? I told you the mischief. They would recuse themselves and then the case loses track. Here we are saying we must be in charge of case management. And we must dispose of matters in a timely manner. Expeditiously. The Constitution sets it expeditiously. And expeditiously is relative. It is subject to so many other conditions. But when a judge therefore says, we are going to proceed in this case, in this particular case, the case was fixed for 1st of September for plea taking. Okay? And the same practice direction in the Rule 8 tells you that if you still have misgivings, get back to the court and let your misgivings be recorded. Okay? And the matter proceeds. At the disposal of the case, you will appeal. But I want to show you this. Many judicial officers have refused to recuse because of the flimsy reasons people want to bring. And they took a judicial oath without fear or favor. Our people there want to think that we want to fear. What are we fearing? The Constitution has given us the mandate. We have taken a judicial oath. We are going to administer justice without fear or favor. You have brought your reasons. I have told you these reasons, as far as I'm concerned, do not constitute grounds sufficient or even to establish the bias you're talking about. I am proceeding because I took a judicial oath to render justice to the people of Uganda without fear or favor. Okay? The rules have told him, go ahead and listen to the case and determine it. When we do that, we are now working against those cases that where judicial officers recuse, and then we have a problem to find the next judicial officer. Because if everyone recuses, who will handle these cases? And this oath and the code of conduct for judicial officers, which helps us guide our conscience, is the top-notch issue that every judicial officer holds on to say, let me go ahead. But I'll tell you, many people have been asked, or they have complained the judge should go out, and the result at the end of the day is in their favor. We have had those instances, and at one point we ask ourselves, so what was the essence of your...
But Your Worship, as you are explaining that very well, something came to my mind.
Yes.
How fair is it that it is the judge sitting in this matter, if the parties in the matter feel is not going to handle their issue, and is again the judge to say that for these matters, I think I can still be neutral?
Yes.
You know?
Yes.
I
told you.
It is like if, for example, let me just give you an example. Now, let me take media. My job to be, if someone says, Robert, you're not going to host me. Why am I not going to host you? He says, I think on that topic you're biased. You know? And then it is me to judge if I'm biased or not.
Now,
then I can come up and I say, no. Personally, for example, if someone can say, no, Robert, for me, I'm from, let me just use any political party. Let me use NUP because it is now the one trending over flags and what has happened, the mess that has happened there. He says, no, Robert, for me, I think you're NRM, because we also get these bullets here where we sit. Someone says, no, my brothers in some stations be taken for opposition. I may be taken for NRM. And someone, no, for you, you are no. Now, and I'm the one to say, but you see, if I look at myself, your allegations are baseless. I don't even have a party ticket, you see. So there isn't anyone else to look into this, but it is me. Is that justice, and how fair is that?
You know, you are bringing a very good example, and you are saying, should I be the one?
Yes.
And this question has already been settled in the rather decided cases. Who is the best person to determine whether he's biased or not?
Yes.
Can you be the one to determine whether he will be biased or not? It should be me, because you are saying I am the one who is conflicted. Okay, and I'm the one who should tell you whether yes or not. I have told you, okay, that a judicial officer by his own motion will recuse himself. What does that mean? That there is a very huge door, not even a simple window, that a judicial officer should be able to think through himself, self-examine, and know, yes, I am. And he does recuse himself. Even when a party has raised issues, as long as those issues are sufficient and are actual, okay, to constitute the apparent bias he's talking about, the judicial officer does that examination in themselves, okay? And if it is true, they will recuse themselves, okay? And have the matter put before another judicial officer. The same person, if he feels that there is nothing that will affect his impartiality. I told you, these judicial officers, we took a judicial oath. Every profession, they have their oath. And I'm very sure it is those ethics which govern our work. Now, a judicial officer has listened to you because it is you who said it.
Yes.
Why should it be another person again to say, yes, I am or not? It should be me.
Away from something political, let's now go to, for example, it's a land thing, you know, a land case before you.
Yes.
And I'm like, but I'm very sure this judge took a bribe and I want, and my lawyers will put it on pen and
If
paper.
it is true, the judge...
How can the judge then say, I excuse myself because...
No, the judge, considering the
Because just
allegation,
to give, yes,
considering the allegation, has the option. But I want to tell you that an allegation like that, that he took a bribe and you are aware, you know the police and the judiciary is zero tolerance to corruption. Why don't you report? So that we investigate that allegation of corruption.
I'm happy I'm discussing
but the
this
judge
with
has
a
told you,
magistrate.
I don't know of any
Proof
bribe.
of corruption in this country is very hard.
No,
Your worship, I know these have come.
No, there is nothing
People
hard.
are so smart
No,
when taking these bribes.
It is you, the public, who are giving these bribes.
Yes.
And it is you
I need
who
to go
know,
off the hook.
It is you who know the person you are giving the bribe. Okay? But because you know, okay, that you are equally accomplices to the crime, you don't want to tell us. We have encouraged you people. If anyone, a judicial officer, seeks for a bribe, there are mechanisms because we want to fight together corruption. Nevertheless, if you are saying the reasons you want me to recuse from the matters because I took a bribe
from the other party,
I want to assume that you even have the evidence. Put that evidence before me.
Sometimes it is hard
now
to
when you
get.
put that evidence before me, I will examine myself. Okay? Because it's first of all it's criminal, and also it's a disciplinary matter. You see? On appeal, if you lost a case and you went on appeal and raised corruption, okay? The judge, the court of appeal will first look at your argument on the bias. And if they are satisfied that yes, there was corruption and there was bias, the court of appeal will make finding on that. You get the point? But bias as it is comes in all forms. It may not even be by corruption or whatever. I've laid the ground on what we call...
I've seen
what may
some alleged relative, husband,
yes.
Those are common.
Yes.
I've had them in court.
And you see, if you are talking about a relative and it is true, I'm telling you, these judicial officers are trained, skilled, they are professional, they have their professional ethics, and they have a strict code of conduct. We have 6 core values. But one of them is impartiality. There's the other one which is relevant to this discussion. All are relevant, but I want to point out another one is propriety and the appearance of impropriety.
Simplify, you're going legal. Your terms. I want my people in Chikubo where to get you properly.
There are ones which are hard to explain. But
you will find ways of explaining.
You see,
because we want them to understand.
Whatever dealings you are doing as a judicial officer, they must be clear and transparent. There must not be very in it.
Hard to understand issues.
That is the impropriety.
Then they tell you, you know, we have alamuzi, toja bitegera.
No, there is nothing we have alamuzi. It is the administration of justice. Towards Uganda, we are serving the people of Uganda. So whatever we do, we must be able to explain it to the people so that they understand it. Why am I bringing this issue? It's because when we saw social media clips and whatever going around, a judge has refused to recuse himself, and then lawyers, moreover, and we see this is where we really feel so, we really wonder. A lawyer who knows that this practice direction directs that when a judge does not recuse, the matter will go on, and you know. And then you are on social media, press conferencing, and then you are telling the public that we are not going to court, we have boycotted court, we are ABCD. We are saying, you know, look, the practice in the courts envisaged that there will continue being that kind of dissent. But the rules have told you clearly, get back to the court and let have your matter proceed. Remember, we are talking about a sensitive case which for all purposes and intents should be expedited.
Yes.
The attempt for recusal was going to again delay it a bit, because finding another judge and moreover a willing judge to take it over, considering the workloads each one have, is another big issue. But now you are telling people that you are boycotting court, you are not going back there. Even the accused is already in the hands of the prison service. So the accused has no option except for known reasons why or how an accused person may fail to appear in court. But saying that he's not going to go to court, no, that's misleading the public, and trying to sow seeds of disrespect to these institutions. That you can be in an institution and refuse what is lawfully required of you to do. That is wrong. Okay?
Because
and
what they were putting forward, I remember, is
request our good friends that it's okay to have different opinions, but where there is clear legal frameworks addressing your problem, let us follow this. What was required? They needed to come to court because the court, setting aside even other matters, was ready to take a plea. And the moment when a matter takes plea in the criminal division, it begins to become a daily hearing case. And as we speak, from 1st of September, if the plea was taken, we would be moving faster. But now you can see all this confusion. Now the case has stagnated because we are back and forth. Secondly, as a lawyer, you should advise your client because you have a duty, a fiduciary duty to advise your client properly. Tell your client, this is the law. We may have misgivings with the law, but that is it. It was passed.
It is very clear. If the judge doesn't excuse himself,
we go back to court and let us hear. If we have issues at the end of the day, we shall appeal. And we shall use that as ground number one to challenge that decision. Because the rules allow you to do that. But let us have, first of all, let us have the hearing court team.
Now,
what assurances do they have that the next judge, whichever judge, will not still be accused of bias? You can see the imputations they are bringing. But nonetheless, whichever way it is, go back to court and let us have the matter proceed. Now, this business of using abusive language against our judges, honestly, what example are we giving the young generation? That we are devoid of any salt, that we can use derogatory language, and it is okay? We are saying no. The law has provided for a self-accounting system. If you have an issue with me, follow the law, okay? Follow the law. The law will address your grievance. Let us not go out there and we start abusing judges, we are abusing judicial officers, everybody, including other officials that are rendering a service to Ugandans. I told you, judicial officers take a judicial oath that they are going to serve the people without fear or favor. And I want to encourage all judicial officers to remember that oath. Don't be intimidated. No one should intimidate you. Okay? Because you have a job to do. Service of Ugandans. Those who are affected by the matters we sit in. And when we are conflicted, the law has guided very well. And I have seen many of judicial officers recusing themselves on their own.
Yes, I've seen quite a number also, yes.
And I've also seen, this is not the first time, where a judicial officer says, no, I have not seen any merit in your application. And I am going to apply the law because I took a judicial oath.
Your Worship, allow me ask this. It may not be directly related to the topic of the day, but are judicial officers independent?
Oh.
Or are there incidents or cases where influenced to do certain things as judicial officers and you comply?
First of all, I want to assure you that one of our core values is being independent in the execution of our work. the judicial oath itself gives us that comfort to be independent. Because if I have no fear, I have no favor, affection, or ill will, I am not discriminating anyone. Everybody is equal before the law. I have the mandate to ensure that my actions, my decisions are mine and not influenced by anybody. Nonetheless, should I start feeling that there is external pressure, that is the influence peddling, I will use the practice direction. I recuse myself. What am I trying to emphasize here? Is that contrary to popular belief, which goes rounds, and there are those who like to make it look like judicial officers don't like people who want to influence them. Many have been told in their face in the courts. I did it one time. I was in Mbale, I was still sitting chief magistrate, and here is this chap. He comes, he thinks that he can influence me, so he comes and he speaks what he wants to speak. I tell him it's all right. What we do, your case is coming up this morning, right? Okay, let's go to court. We shall talk about the details after court. Comfortably and confident that he has delivered his message, we go to court. And the first thing, in the presence of everybody, their lawyers and the other party, I informed them that before I'm coming to court, Mr. So-and-so, who is a party to this case, came to my chambers and said he wanted to influence me. And I wanted to make it clear that I am not available for such conduct. And for that reason, I'm recusing myself from this matter. Because even if I'm not compromised, but if I, in any case, went ahead to hear and sit in the matter and decide it and went against the other party, even if I did not take any bribe, the other party would think it was, but I was transparent enough. You know, the truth sets you free.
Indeed.
As a Christian, we know that if you are living in the light, you live a very wonderful life, a life of grace, you know. So, any influence peddling from whichever angle, our judicial officers are encouraged to use the practice direction and they recuse themselves if they think that that influence peddling will influence their decision. Nonetheless, if it doesn't, because they took oath to administer justice, okay, without fear or ill will, or even whatever prejudice that may be, they are required to proceed and deliver justice. We are in an era of innovating good practices in case management. And so we cannot allow such unfortunate practices which manifest themselves as recusals to take over the management of courts.
Which will lead to
that
case
the person
backlog.
can even go and say, I'm protesting because I did not want X and Y and Z. And this is the message I want to send home. Lawyers, we are all officers of court. You are officers of court. You have a duty both to the public and the courts. You shall not be the one, again, to frustrate the administration of justice. If there are any errors, lapses, omissions, or any dissatisfaction with the decisions of the court, the due process is available for you. And you know it, you have read it at the university, you have done it at Law Development Center and all the other centers. You have been found worthy to practice law. That means you know what the law says. Let us not do politics instead of being lawyers. or advocates. And I want to thank the team from Mpanga and the company advocates. While the others were out there ranting and saying whatever they are saying, Mpanga and my brother Mpanga and Kalibala were in court to inform the court about the instructions they wish to get from them. And that's what we want of a lawyer. Get to court. They might have had misgivings too. I don't know. I'm not ascribing anything. But they came back to court because they respect as officers of court. They came, and I want to give them salutations. They are a good example to our younger generation of lawyers. The lawyers who know decorum is very important. Etiquette is very important. If you're a lawyer, you don't have discipline, then you are in the wrong field. This is a noble field.
Well, time is so much against us. I must have been listening, and I'm sure at least if it comes to recusal, now I can advise very well. At least I know that it's not...
There's one thing I wanted, something I wanted to say.
Okay, just use that in your parting shot.
There is a small issue which is causing confusion about the file having to be in ICD as opposed to the criminal division. That's wrong. ICD only handles 4 categories of cases. One is war crimes. The second category of cases is money laundering. The third is trafficking in persons. Okay? And the fourth is, what's the fourth? There are 4, but out of these 4 categories, okay, treason is not one of them. And there is a special instrument which created the International Crimes Division, and it gave that, you know. So when you come out and you start misleading the public that the file was supposed to go to ICD, no, that is a matter before the criminal division because it is treason and a misprision of treason. And those are matters which remained in the criminal division, okay? Whichever errors, okay, or mistakes that they are riding on, that cannot be, again, the position of the court. So, as a court, we want to inform the general public that the charges against our elder, Dr. Kiza Besigye and Obeidi Lutale, are matters that are triable in the criminal division of the High Court, not ICD. The categories under ICD, I have mentioned them, not this particular case. And anyone who is trying to mislead you there is just trying to push a different agenda. Okay? So, we shall continue supporting the sensitization program because whenever we realize that there is a deliberate effort from our friends and stakeholders to confuse the public, we come. And thank you for listening to us. I bring you greetings. As a judiciary, we are committed to ensuring that we serve you well and we give justice to all. Thank you very much, and may God bless you.
Thank you very much, Your Worship, who is also the spokesperson of the judiciary. Thank you so much that whenever we call upon you, you know why I can't stop disturbing you is some of these issues. Also, if we don't understand them properly, you're there to explain them to the public. Like one thing I've known today is that recusal is not a must, that a judge automatically, because you've requested for it, the judge automatically will move out of that case.
No.
There are terms and conditions. And one and the major term is if the judge finds the reasons you've presented are not sufficient enough to indicate he's biased, then the case will continue. At the end of the case, you can appeal and use those grounds. Now, these are some of the things that many Ugandans don't know. For us in the media, we'll say, well, if they requested for the judge to recuse himself, it is a right. Why hasn't he done so? I remember that was my phone call. If I don't want you in my case, but I'm happy that you've come and expressed that. Same as when we were talking about bail. It's my constitutional right. Not until you get to know that, no, there are terms and conditions where the presiding judge can deny you what you think is your constitutional right. So let's interest ourselves.
The other category was terrorism. I was trying to...
Okay.
Terrorism. So Dr. Kiza basically is not charged with any of those four category of cases. He's not on terrorism, not on human trafficking, he's not on war crimes, he's not on money laundering, which are the preserve of the other.
So you can't take a case there. Well, let's interest ourselves learning these things, because at the end of the day, they benefit us so much. Thank you, Your Worship, for your time. Well, I must go. Have the best of your weekend. God bless you.
Yeah, we need more time.
Live from UBC Studios in Kampala. This is Good Morning Uganda Extra.
Honorable Fred Biamukama, Minister of State for Works and Transport in charge of transport, invites you to the second phase of the 4-acre model campaign in Greater Bunyoro sub-region. The event will take place at Nalweyu Primary School Playground, Behimba Road, on Saturday 20th September 2025 at 10 a.m. and will be graced by His Excellency President Yoweri Museveni. All residents, civil servants and leaders from the districts that make up Greater Hoima, Greater Masindi, Greater Chibale and neighboring areas